because nobody has a vested right in procedure. You have submitted your bid documents. It was being vested. It was being vetted. Whichever process it had reached, unless there has been an award, you cannot give what you don't have.
All right.
So Vamed purported to give to Waterville something it didn't have. It surprises me that the previous government didn't immediately terminate the entire process and say, this is over, Vamed, you are out. They continue to do...
They weren't aware, because if you read Osafo Mafo's letter, writing to Vamed... No, the letter itself.
Okay.
He wrote to Vamed.
Okay.
Now, if you look at the date of the letter...
This is shocking.
Yeah, if you read the date of the letter, the assignment was supposed to have been done. Now, if you read the letters of assignment, nowhere in those letters is government copied. Whether the minister, whether the tender process. So, in communicating the decision not to continue with the process, the letter was addressed to Vamed. But it was at a time where the supposed assignment had already occurred.
So we may ask questions. Did an assignment really take place? And is an assignment valid? And even if it was an assignment of a vested legal right, the same Section 7 provides that there's a mandatory requirement to give notice to the third party. And you and I know that as common law, you can't assign a liability without the consent of the third party. So on 3 legal grounds, that process should have been terminated. So maybe the termination that the government did was fortuitous, because legally the bid process was over. So the government terminated it. Now, these matters do not appear to have engaged EOCO's attention. But look, there was a time crunch. And so this whole thing about something having been terminated and requiring investigation, to me, crumbles completely, and has absolutely no legs to stand on. These are some of the things that I believe EOCO's final report will deal with. For example, there are other illegal issues. Exactly what did Woyome go to court for? And it to take you reading his statement of claim to see exactly what he went to court for. First and foremost, he pleads that there was a contract which was entered into. He doesn't plead the particulars as to party. So we would have to see that in law, let's go back, that the minute Vamed purported to assign, its bid was over. Okay. So the government termination of it, although it wasn't based on this ground, really fell in line with what the law would have required on the basis of Section 7 of the Contracts Act. Okay, good. The other thing that I think we haven't paid particular attention to is the exact nature of Mr. Woyome's claim in court. First of all, he pleads a certain contract, which we now know is the Waterville contract, and to which he was not a party. He does not particularize his plea to state who the parties are. Then he claims another agreement under which the government agreed that he should earn 2% of whatever sums he managed to arrange for this project. Okay. He doesn't particularize the agreements. But we know that under our State Properties and Contracts Act, Section 20, if you want to enforce an agreement against the government, you have to produce an executed contract, executed by the relevant sector minister or a person authorized by him. He doesn't plead any such particulars to show that any such executed contract was entered into involving him. But his actual claim is based on a further claim that he made. He wrote letters, he calls them correspondences, to the Attorney General's Department and entered into a further agreement with the Attorney General's Department that he would be paid 41 million Ghana cedis, which was the cedi equivalent of 22 million euro. He says that on 6 April 2010, the Attorney General wrote to the Ministry of Finance, on 6th, Attorney General authorized the Ministry of Finance to pay, and that on 6th April 2010, the Ministry of Finance approved payment. Now, this is a man who said he had no contract, but the Ministry of Finance approved payment of 41 million Ghana cedis for him. And the approval went to the Controller and Accountant General's Department. The very next day, this is great speed, they issued what they call a bank transfer advice. This is his plea to Bank of Ghana to pay him. Then something hit a snag, thank God. Somebody somewhere started asking questions. And so within 12 days of the 7th of April, he was in court. So his claim was that the Ministry of Finance, in breach of his agreement with the Attorney General's Department and the authorization of the Attorney General's Department, had failed to pay him. And that's why he was in court. So the direct contract he was in court to enforce was a third contract that he had entered into, an agreement he had entered into with the government of Ghana, acting per the Attorney General, that he should be paid and that the payment process had been triggered but the payment process had been stopped along the line by people he does not mention. So it's very critical that in EOCO's final report, they would have to start tracing these the sequence of events and asking questions. Wait, hold on. What did he bring? What did he provide? Whom did he speak with? Who authorized what? What documents supported the preparation of a bank transfer advice? And what led to the stopping of the payment? Right? So all of these are issues that I believe the report may deal with. But the other thing, hasn't EOCO's functions been overtaken by events? The CID has stepped in. And clearly, nobody's going to go to court to prosecute and tender the interim report as evidence. CID will have to gather all of its documents and all of the evidence. Will go in. Some of the evidence may go in. Objections might be sustained with respect to some of them. So probably EOCO itself has been overtaken by events. CID has taken over something that we probably should have referred to them right from the beginning.
So you think that this report, interim report, really doesn't carry much weight?
Oh, it's informative. It says very little that we didn't know.
Okay.
Like the bribery thing was new, but in substance, I think that those of us who have been following the story know a lot more than EOCO's interim report speaks about. But let's give them the credit. Okay. They did what they could do, right. But there were clearly time crunches, and this is an interim report.
Randy, I've heard comments that this document is self-contradictory in certain places, and that it says one thing in one area, turns around to suggest something else in another area, and that perhaps weakens it. I'm sure you've heard these views. Do you see any such contradictions?
I even came to the same conclusion. I think that first of all, as has been stated here, it is an interim report. Secondly, if you read the report, the EOCO itself laments about limitations with respect to the fact that certain personalities who they believed could shed a lot of light on some of the things that have come to their notice did not make an appearance. And here they speak about those who went to court. And then, interestingly, they bring in the former Attorney General, who they say submitted documents but refused to give oral evidence. And that she referred to the court suit filed by the others. They mention some other names, but they actually do not tell us whether they invited them and they didn't come. So I really do not get how come their names were just splashed there, and there's really no, because it mentioned names like Mr. Rex Dankwa, Honorable Jogate, Honorable Dr. Kotoso, Honorable Kwekwajimameno, and he ends there, it doesn't say anything.
Thinking about the subheading, the rules of certain personalities.
Yes. Right. And it says it is possible, however, to determine roles played by some persons while further work is ongoing to establish the roles of others. And so the fact that this document is not conclusive, there's a little difficulty in dealing with the document, because there will always be the alibi that when we are done, those things will be there. But there are a few problems. One of the key things with respect to this particular matter has been the conflicting figures that have been churned out by state agencies. Now, this EOCO report worsens the situation, because in this report, it talks about first payment made in February.
It's probably a typographical error.
Yeah. No, I'm saying that this is a report that has been presented. These issues come out.
I'm being kind.
Yes, I would expect that. I would expect that at least the EOCO will issue a short statement just to clarify it, that indeed it was a typo or it was a mistake or it was whatever. Because now, if you talk about, for example, the president's intervention, and you give timelines as to when the president intervened, and then the same document talks about payments that preceded the interventions of the president, then obviously anybody who takes the document and analyzes it would come to a certain conclusion. You understand me? The conclusion that you're not being, for want of a better expression, let me say that you didn't do a diligent work. You understand me? And I'm saying that it's been too long a time for typos and mistakes not to have been corrected. At least they are out in the public domain. We are discussing them. We're raising the inconsistencies. You should deal with them and say that, oh, we're wrong. We got it wrong. This is not how it should have read. It should have read this way. Your continued silence creates the impression it should have read October.
Okay.
October.
Okay.
You understand me?
Yeah.
Your continuous silence then creates the impression that you still stand by what you put out, especially when at the castle the president gave a directive that it should be put out in the public domain for everybody to see. So it's a material for public discourse. You understand what I'm saying? Now, as I said, there's nothing new apart from the 400,000 and the president's intervention on 2 occasions.
Okay. I'm trying to prevent my panelists from assuming that everybody is on it. I know you're referring to Nekwe and his wife and all that, but the 400,000, you'll be surprised not everybody knows what that is about.
No, the report says that they cited 400,000, a payment from Mr. Woyome, into the account of the Chief State Attorney's wife. Right. You understand me? Mrs. Nekwe. Right. Now, interestingly, in this report, the EOCO does not tell us that they invited a lady. Because you find money in somebody's account, you should ask the person, what is the money doing in your account? Or ask the husband, or ask Mr. Woyome what the transfer of funds to that account was for. But the report does not tell us. So even if that happened, we are not told in this report. But I thought that at least if you found some unusual transaction and you're an investigative body, you ought to ask the people involved what that money is doing in the account and what is it for.
Do you think that it formed the basis for the CID's action, or that the CID was going to do its own work relative to this lady? Because then she was granted bail. I believe she was the only one who was granted bail because she's a nursing mother.
But if you look at the charges, it appears that she is there because of 400,000. Okay. Yes. If you read the charges, she's there. Yes, she's there because of the 400,000. You understand me? But the report doesn't tell us that. Now,
the report says, as said above, permit me, on page 15, it has been detected from his bank statement that he made a payment of an amount of 400,000 Ghana cedis to Mrs. Gifty Nekwe Tete, the wife of Mr. Samuel Nekwe Tete, on June 16, 2011. That's all it says.
Because if you look at this same report, there are actions of people, and those people are questioned about the actions. Mr. Nekwe Tete was asked why he didn't go to court, why he didn't do this. He gave reasons. As to whether those reasons make sense or not is another matter. In the case of Mr. Polasimeni, he was asked, why did you do this? And he said, according to the report, that he concocted things and all those things. So they were questioned. You understand me? So I'm saying that at least you'd expect that an investigative body, in putting out this information, would also try and find out from those people what happened. But it's not here. If they did it, they've not put it in the report. But when it comes to the issue of Waterville, I get the impression that somebody was in a hurry to pass Waterville. Because I first of all do not get the issue of Honorable Osafo in this whole thing. Because if the task was to go and investigate judgment debts, the first question I ask myself, is there any judgment debt which is arisen out of the truncation of the central tender process? There's none. No organization, entity, or human being has taken us to court and won a judgment debt on the basis of that central tender board process involving VAMED, which was terminated by the Honorable Safumafu letter. So I really don't get how we go and deal with that issue, because in the same report, it then narrates all those things and say, subsequently, then it talks about the MOU with Waterville, which was subsequent to that whole central tender process, which had nothing to do with Waterville. And then it talks about the termination of the Waterville contract. That was done by the then Attorney General Jogate, not Osafumafu. And Jogate gave reasons. If you look at his letter, it was a contract that was a condition precedent. I guess that's what you lawyers... He had condition precedent. And he says that, pursuant to section 17, whatever of it, you have not fulfilled it. On that basis, we are terminating. Now I have a letter here from Waterville to government. Waterville itself accepting government's termination and saying that, but we've gone to site and done some jobs. So pay us. That is what we want from this thing. And so the consultants certify and they are paid their monies. Now the EOCO comes to a conclusion that the people were owed some monies after January 6, 2009. How they came to that conclusion,
there's no link. I'm
amazed. They do not give any... It appears that this is Waterville's narration, that we were owed X, we were paid 11, we were not paid this. Waterville themselves, in their letters to government, say that pay us through Consa and Micheleti. Now, nowhere in the report are we told that Consa and Micheleti were invited to the EOCO.